There's lots of news on the Supreme Court as they take up a whole bunch of cases, and which ones do they take up and which ones do they reject? And I'll give you guys the news on 3 cases. Welcome to the Doug TenNapel channel, where we love Clarence Thomas for a lot of reasons, and he doesn't let us down by the end of this show. First up, we're at the Hill. Supreme Court will review FBI's immunity in lawsuit over mistaken house raid. Does the FBI get to accidentally raid houses? The Supreme Court said Monday it will review whether the FBI should have immunity in a lawsuit brought by a family whose Atlanta home was mistakenly raided by a SWAT team. In 2017, agents executed a search warrant at the wrong address, believing it was the home of an alleged violent gang member. The warrant had instead listed an address 3 houses away. So that's criminal neglect of the FBI. Armed and dressed in full tactical gear, the agents breached the family's home before sunrise and deployed a flashbang grenade at the entrance. Hillard Clea was handcuffed. His partner, Katrina Martin, was held at gunpoint, and Martin's 7-year-old son was also home. Court documents show, whoopsie. Agents realized they had the wrong address within about 5 minutes when they started asking questions and going, hey, what's the 7-year-old boy doing here? Sorry. They immediately left and proceeded to arrest the alleged gang member down the street. FBI Special Agent Lawrence Guerra, who led the team, returned later in the day to apologize. He also promised to pay for damages and left a business card. Sorry about the flashbang grenade. Family sued the FBI under the Federal Tort Claims Act, which allows private citizens to sue for damages when federal employees commit wrongful acts. The Supreme Court, in a brief order Monday, agreed to take up the family's appeal after lower judges found the FBI had immunity from the lawsuit. So we're going to take a look at the FBI immunity, and I think it's a good time to remove all FBI immunity. The High Court normally only takes up cases for the current term through mid-January, but the justices set a slightly faster than usual briefing schedule that enables the latest case to still be heard this term, which would culminate in a decision by early summer. It follows a batch of cases on Friday, which we already went over. The High Court similarly squeezed in for this term, including a push to create a first public religious charter school. Yay! The late new cases come as several disputes already on the court's docket could be shelved as President Trump's Justice Department considers policy shifts that would render them moot. So one example of that, which we already went over, that would free up space on their docket would be Biden's government loan forgiveness program that Trump's going to cancel. So it doesn't matter if it's constitutional or not. They don't have to look at it because it's not pending. It's not going to happen. Okay, next article. Okay, this one is the U.S. Supreme Court leaves Mississippi's Jim Crow era felony voting ban in place. Now, this headline is completely loaded by the Mississippi fake news free press. They don't have to say Jim Crow era felony. We know what that, the felon, they don't want felons to vote is what the Supreme Court is saying, or they're not going to take up the case. Now, Mississippian Democrats, they always want felons to be able to vote, and the Supreme Court's just saying, look, we're not going to take up this ban. In other words, you could take it up. It's probably a state's issue on who gets to vote or who doesn't. It's also a little ironic that we're forgetting about one certain felon named Donald Trump, who under many state laws wouldn't be allowed to vote. Now, does that have to do with Jim Crow? Is that because Trump is so black? Here's just a few lines from the article. Washington, Associated Press, the U.S. Supreme Court on Monday left in place Mississippi's Jim Crow era practice of removing voting rights from people convicted of certain felonies, including nonviolent crimes such as forgery and timber theft. They tried to pick out 2 of the least offensive crimes, forgery and timber theft. Well, they're a felony, so you'll have to take that up with the Supreme Court or with your own state. The justices, without comment, turned away an appeal from Mississippi residents who have completed their sentences, but who have been unable to regain their right to vote. They'd all be voting for Trump anyways. The court's action let stand a ruling by the full Fifth U.S. Circuit Court of Appeals that rejected the claim and permanent loss of voting rights amounted to cruel and unusual punishment in violation of the Constitution. Mississippi legislatures, not the courts, must decide whether to change the laws, the Fifth Circuit said. There you go. And that's basically what the Supreme Court is agreeing with. Wow, how did I guess that? I'm a barely literate comic book artist. Using different legal arguments, lawyers failed to get the Supreme Court to take up the felon disenfranchisement issue, another loaded word, in 2023 over a dissent from Justice Ketanji Brown Jackson that was joined by Justice Sonia Sotomayor. So they dissented with the rest of the court. Ketanji Brown Jackson and Sotomayor. Notice Clarence Thomas did not dissent, just in case you're trying to make this into a race issue. Mississippi's list of disqualifying crimes was adopted for an illicit discriminatory purpose, Jackson wrote. There's the petition for writ of certiorari. That goes down the tubes into ancient history. Next up and finally, we have the Clarence Thomas bomb throwing competition where he lets one go on him. Clarence Thomas calls out judges for disrespecting Supreme Court rulings. Oof. Supreme Court Justice Clarence Thomas slammed a Circuit Court of Appeals for not adhering to legal precedent in a dissent released Monday. Thomas dissented from denial by the court to review a lower court's decision. Justice Sam Alito joined the opinion. Quote, this is Clarence Thomas. He's just roasting him here. Because I would not overlook the Sixth Circuit's blatant and repeated disrespect for the rule of law, I respectfully dissent, Thomas said in the dissent. He's saying he can't be a fair judge. He can't overlook the Sixth Court of Appeals being too political with this. Here's why it matters. Thomas's dissent focused on the Sixth Circuit Court of Appeals application of the Anti-Terrorism and Effective Death Penalty Act, the AEDPA. The law limits federal courts' power to review state criminal convictions. Thomas said this case is the latest in a long line of AEDPA errors made by the Sixth Court. The Supreme Court has reversed the lower court's decisions at least 24 times. 24 times this radical circuit has been reversed for misapplying the statute, according to Thomas. What to know? David Smith, an Ohio man, was convicted of attempted murder, felonious assault, aggravated robbery, and aggravated burglary after he attacked Courtney Tulliver in her mobile home in 2015. Before the trial, Smith asked the court to suppress Tolliver's identification of him as the suspect, arguing that law enforcement was, quote, unnecessarily suggestive, unquote, when interviewing her. The motion was unsuccessful, and the evidence was admitted. Imagine that, anytime a law enforcement person was overly suggestive in interviewing someone. In the appeals of the decision, Smith renewed the argument for the suppression of Tolliver's identification. Overall, Johnson did not merely suggest that Smith was the perpetrator, but rather explicitly informed Tolliver several times that Smith committed the crime and he tried to kill her. The Sixth Circuit Court of Appeals wrote in its ruling, the Sixth Circuit directed the district court to issue a writ of habeas corpus unless the state can hold a new trial within 180 days. The order would require the government to prove to a judge that there is a valid reason the defendant is in jail. Thomas said the lower court's majority errors that were particularly egregious. He said, quote, the panel majority's errors have real consequences, Thomas said, and this is why he doesn't want anything to do with this case. Quote, the state of Ohio must retry Smith for a crime committed nearly a decade ago. That result comes at a steep cost for both society and the victim, so he's looking out for the victim in this case. He said he would have reversed the Sixth Court's decision, quote, to ensure that federal courts do not exceed their very limited role in collateral review of state criminal convictions, unquote. A dissenting opinion by Thomas is written by a Supreme Court justice who disagrees with the majority opinion in a case. Dissenting opinions are not law, and future cases are not required to follow them. The opinions allow justices to represent minority viewpoints on contested legal issues. And now you're all caught up on the Supreme Court. Justice Thomas has largely removed himself from that case, by the way, which may give a win or a windfall to that Sixth Circuit because he didn't participate, given he dissented. But we'll keep you up to date. What do you guys think of these three cases? Love to hear your comments below, of course. We're not legal scholars. We're all just giving our opinion here. But I know that I trust Clarence Thomas probably more than any other judge, that he's a principled man and probably our greatest Supreme Court justice in my lifetime. I'm Doug in exile. Look, you can subscribe here, watch another video here. Anytime you watch another video, it helps push this video out to all kinds of other people. So thank you in advance.